The Supreme Court yesterday reiterated its disapproval of the Calcutta High Court verdict advising adolescent girls to control sexual urges and said that the writing of such judgments is absolutely wrong. Earlier also, the top court had commented on the Calcutta High Court for its observations, asking young girls to control sexual urge and not give in to 2 minutes of pleasure. The Supreme Court termed the Calcutta High Court's comments both objectionable and unwarranted, saying judges should not preach. Now, it was in October in a POCSO case that the Calcutta High Court had observed that every female adolescent should control sexual urge, as in the eyes of society, she will be a loser when she gives in to enjoy sexual pleasure of hardly 2 minutes. The Supreme Court, which had at the time taken suo motu cognizance on December 8th, had issued a notice to the state of West Bengal and sought to know if the state intended to challenge the judgment, and that took place yesterday. Well, to talk more about these observations that were made by the High Court and, you know, the statements and what the Supreme Court has now said, we're now joined by Ashwini Dubey, advocate of the Supreme Court, and Dr. Ranjana Kumari, director of CSR and an activist. Thank you both for joining us. And Ranjana Kumari, first to you, your comments on firstly this sort of regressive thinking that was so apparent in what the High Court had said, and then the Supreme Court, calling it out and showing its disapproval of such statements, saying it's not the job of judges to preach.
Well, we really welcome Supreme Court's judgment and also their statement about, to limit the High Court's judges' personal observation. These are their perhaps personal opinion about things, and they should not, while they are interpreting the law, they should not really bring all these observations which are completely unnecessary, and also they are very sexist in nature, and they come from their own personal experiences that they may have gone through in terms of their own socialization. I feel, this is not the first time. High courts have come with bizarre judgments like telling a girl who has been raped to marry the rapist. They have talked about a woman to not go for an abortion. I mean, so many such judgments we have come across. And now to become, kind of moralizing over it, become, talking about all kinds of ethical things. This is not the job of the court. And also, how do they know what the sexual urges of a teenage girls are? Are they any kind of, doctors, physiologists? What kind of a statement is this? So I feel that, high courts will have to now grow up a little bit and see where the society is moving. Look at the way, young men and women are asserting not only their sexual rights, they're also asserting their sexuality. So they really have to understand all this now, instead of, talking about these British ethics and, all old kinds of things about sermonizing the relationships. How can you tell a teenage girl or a boy for that matter to control their sexual urges? I mean, what are they talking about in this time and age? So I feel not only this is sexist, this is also extremely, misogynist kind of a thinking that is leading to such kind of judgments.
No, absolutely. And Ashwini Dubey, if you could elaborate more on this, that this is not the first time the Supreme Court has had to come in. We do know in 2021 as well, the Supreme Court had in fact issued detailed guidelines on how cases of sexual assault should be handled with, a lot of sensitivity, the correct language, and sticking to the law, not coming in, not bringing in your own moralistic and regressive thinking into the matter.
Yes, Gargi, even if you remember, the Iskin to Iskin judgment was passed by the Nagpur bench of Mumbai High Court. Even in that case, the Honorable Supreme Court intervened and said that, look, you are not there to interpret what is stated in the statute. You have to pass the judgment based on the material or the order which challenged before court. It's there. Now, here in this case also, Gargi, the said observations, as noted by the Supreme Court, is in violation of the rights of the girls or adolescent girls under Article 21 of the Constitution of India. And that is why the Honorable Supreme Court says the issue before the High Court was the legality and validity of the order and judgment which was challenged, for which a man was convicted for the offense under Section 363 kidnapping and 366 kidnapping, abducting and inducing woman to compel her marriage of Indian Penal Code, and Section 6 of the Protection of Children from Sexual Offense. And that is what the Honorable Supreme Court took the suo motu cognizance when it found that the Calcutta High Court, which made news in December, saying that they should control their what I don't want to use that word, but as per orders of Honorable Chief Justice of India, suo motu writ petition under Article 32 of the Constitution of India was initiated, which is one of the wonderful thing by Honorable Supreme Court. And Honorable Supreme Court said so many issues which were irrelevant. And the Honorable Supreme Court said that prima facie we are of the view that while writing a judgment in such appeal, the judges are not expected to express their personal views. They are not expected to preach. And Honorable Supreme Court very validly, very rightly, in order to protect and keep the paramount of the modesty of a girl and also the rights under Article 21 of the Constitution of India, has passed this judgment. We welcome it, and we also expect that in future these kinds of judgments should not come from the other parts of the country.
Right,
Yeah.
absolutely.
Gargi,
welcome the Supreme
Gargi,
Court
I have a
stepping in
point
here
here.
with these, with its strong disapproval in this matter, saying judges shouldn't preach, making this point that, there's no need to be moralistic. And as Ranjana Kumari, as we said in the past as well, the Supreme Court has called out these sort of, misogynistic, regressive statements. Are you hopeful with this? So in a sense, public shaming, it is what it is. I mean, the Supreme Court saying it disapproves, but it is public shaming that we're seeing. Hopefully more courts will, be more sensitive to these matters going forward.
I think also the Supreme Court was having been reversed so many of such judgments and made comments about these judgments. I think it's important to use this judgment at this stage to create some kind of a guidelines for the high courts, because this is not, high courts are really going far and beyond their own mandate, their own, boundaries, and trying to, especially in the cases of women, especially when they have to make any kind of judgment about pregnant women, about women who have gone through sexual assault, women who are, different kinds of, sexual experiences that women are going through. They must issue a kind of guideline for the high courts. I am sure it is within the purview of the Supreme Court to issue such a guideline that they must restrict themselves to looking at various kinds of evidence produced for the courts, and also the legal framework within which they must make their observations. Not unnecessary things. Every time we have to come across these kind of sermons coming from high courts and women, and these are having long impact. So they should understand that they are really taking the society backwards. We have worked years and years and years hard to really change the mindset of people, and now look at the courts. I mean, they are the temples of justice. This is no way of delivering justice.
Right, Ashwini Dubey, I'd like you to also just comment quickly on this. Are you hopeful with the Supreme Court calling this out, that the message should go across to the high courts and to the judges not to make such kind of comments? Though we do know that in 2021 as well, the Supreme Court had issued guidelines on handling such sensitive cases.
Gargi, one thing is there are numerous judgments passed by the Honorable Supreme Court with respect to the protect the right dignity of a woman. But here in this case, there are certain limitations to the Supreme Court. Or Supreme Court only pass an orders for the guidelines, but cannot restrict the High Court, because the jurisdictions of the High Court and Supreme Court, unless and until the matter come up before the Supreme Court challenging any order, Supreme Court normally differ from passing these kinds of. But yes, this judgment itself is landmark, and we are hopeful. You remember, Gargi, the judgment passed by the Kerala Sessions Court, where the certain observations made by the Sessions Judge while dealing with the sexual assault matter, skin to skin, we have already discussed. The October 21 judgment we have already discussed. In past and even as of now, the passing of these kind of judgment itself is a clear message to the courts of the country that look, instead of dealing with the matter on merits, you should not comment about what is happening outside. You should not preach. The morality should not come in a judgment. You should decide a matter on the merits of the case. And
absolutely. Judges should not preach. That is what the Supreme Court has said. Thank you so much, Ashwini Dubey and Dr. Ranjana Kumari, for joining us on the program.